Welcome, viewers. Just gonna do a short little lecture here. Um, from some. It's one of the things that I sort of touch on in my book. We're gonna look at the history of the Constitution, really. Um, Maybe a few themes from it. Sort of arguments over the benefits of certain elements of the Constitution, and maybe some of the drawbacks as well. So yeah, let's rip into it. Just trying to think the best place to start. I think our constitution is obviously uncodified. A lot of people refer to it as being unwritten, which is a term that I'm a bit more hesitant to use, because yes, our constitution is not set out in one big specific document, such as in the United States, but rather it's a collection of, doctrines and principles and but there are still documents that influence our constitution and form part of our constitution. So I prefer to use the term uncodified. It's not codified within one specific document, as opposed to being unwritten, because that there's things written that form part of the constitution. So yeah, this the uncodified nature of our constitution is sort of evolved as the outcome of almost perpetual political pressures. So I suppose sort of providing a bit of historical context is a good place to start. So yeah, some people view this historical development as fairly random, driven by short-term chances and personalities. Some people argue that there are rather larger forces at work driving the Constitution. So I think one of the first relatively important stages is the origins of the crown in the Saxon period. The monarchy is the oldest institution, and in legal terms is still the keystone of the Constitution. Um, and in theory, all legal power actually derives from the crown. According to the myth of the ancient constitution, the king ruled subject to the consent of the council, known as the Witan, representing, the sort of leading citizens of the time. So you could say, or it's almost a fact, that by the end of the 10th century, you have this sort of complex system of local government that it existed within, local counties, and some of that actually still exists today, still remains today. So it's only really in the medieval period that the beginnings of parliamentary government and common law emerged. After the Norman conquest in 1066, the king claimed jurisdiction over the whole of England. By the 16th century, he claimed jurisdiction over Wales as well. So the power of the monarchy derived from the hierarchical feudal system of landowning, with the king at its apex. The chief landowners and church dignitaries form the king's sort of council of advisors, which he could, summon whenever. And it's through these people that he actually issued laws. And some of the original powers of the monarchy still exist today in the form of the royal prerogative. But we'll get onto that later, I reckon. So you have this event that happens in 1166, which basically established the king's power to administer law through judges and juries, and you have these judges that travel around the country. They travel around administering justice in the name of the king, in the name of the crown, which essentially is the start of common law, as a system of domestic law. Even when it's far in these times to avert that the king himself is subject to common law. So that it's an extremely significant event that occurred in constitutional history. The development of the system of common law. Which being that the decisions that these judges make in the name of the crown essentially form the law itself, and it's still used today. A lot of common law doesn't necessarily go back to the time of the reign of Edward the First necessarily, but it goes back a very long time indeed. So when this sort of period of baronial domination began to collapse, that's when um, Parliament, which is now the most dominant institution of the Constitution, began to develop. Um, Sort of came around 13th century as a meeting of leading landowners and officials summoned by the king whenever he wanted, essentially. Um, just to transact business, hear appeals from the courts, which actually remained, I think, until 2008, is when the House of Lords was abolished as the final appellate committee of appeal, replaced by the Supreme Court, dictated by the provisions of the Constitutional Reform Act 2005. But, that was a practice even way back then. It is a striking example of how a lot of the elements of the Constitution stems from history like this, and how far back it actually goes. So yeah, you've got the House of Lords, which is kind of comprised of your barons and your church dignitaries. And then you've got the Earl of Leicester, who pops up and basically he says we need to have local dignitaries representing their communities, essentially, and summon them together with Parliament. So he essentially gets the credit for coming up with that. And that was in about 1265. So that's a bit nuts, considering that's like a democratic principle that he's advocating for there all the way back in 1265. Maybe that's nuts, maybe it's not. Depends on who you ask. But that it's significant, a significant part of our constitutional history. The Earl of Leicester coming up and saying we need to have this. It happens. The Commons send their representatives to the Lords, and then eventually they start to meet on their own. The Lords don't really care. They're focused on their own thing, their own members, and both houses are making grants to the king, so the king doesn't really care. He's getting his cash, he's getting his coin. So it's just something that kind of happened. It developed kind of unchecked. Well, not unchecked, but without dispute, I would say. But a key development during this time was that there was a ruling that said, the king cannot summon the Lords on their own. This was rendered constitutionally impossible, which is important when we get onto what we're going to talk about next, which is going to be about the context and the events of the English Civil War, which is one of the most, if not the most, constitutionally significant event in history. So, as a sort of brief overview, you've got Charles the First, who's run out of money and he's under pressure, military pressure from Scotland and Ireland. So he just goes and he claims the right to exercise royal prerogative to, raise taxes from Parliament. Which obviously, they're going to kick off about. So Parliament presents a petition of right in 1628, which Charles actually accepts. But he refused to regard this as binding. He accepts it. He basically says thanks, but no thanks. And from 1629, he just goes off and does his thing without Parliament. Does what he wants. This went on for a little bit, and then Charles, 1639, he tries to impose the Anglican prayer book on the Scots, and things didn't go too well for him. There was a mass uprising, so he tries to summon Parliament, get a bit of money, And this parliament just dropped the anchor. It became known as the Long Parliament. Um, and it's one of the most notable parliaments that's ever sat in our history. They dropped the anchor. It went for 20 years. Um, but we say this went for 20 years, but it was actually suspended for most of its duration. But in technically speaking, it was sitting for 20 years. And so it all comes down to religion back then, money and religion. Well, there's different views. People have different views, but religion was a massive part of it. You cannot deny that. The Church of England, headed by the king, just flat out refusing to accommodate Puritan and Presbyterian demands. And that fueled the sort of political conflict, which did lead to the Civil War, as we spoke about just now, between the Royalists on Charles's side and the Parliamentarians. One thing led to another. Off goes Charles's head. Thank you, we'll see you next time. Then you've got the Commonwealth period that you can look at as an example of radical constitutional experimentation. The Commonwealth period being the period of republicanism, obviously, with Oliver Cromwell, who called himself Lord Protector. Make of that what you will. But so Cromwell basically says Charles is outrageous. We need to get rid of him. Installs himself Lord Protector, and he just wielded this immense amount of executive power. And despite his Republican ideals, he was incredibly autocratic. And as we know, it didn't end up so well for him. The restoration of the monarchy came about in 1660 under Charles II. Didn't necessarily remove some of the revolutionary ideas that had bubbled to the surface as a result of all this conflict, but it did sort of mark a return to the more traditional structures of governance. But I think the key takeaway here is that you have this notion, this idea that a monarch could be held accountable by Parliament. That had been firmly established by now. Because you've just seen Charles's head chopped off. So, that's a key takeaway from this period. And then when you have the Glorious Revolution of 1688, James, he attempts to reassert royal authority through his Catholic sympathies. Didn't go so well. This is a common theme here. A lot of them just have these nuts religious ideas, and they just try and pose it, come what may. Didn't go well for James. And then William of Orange comes in from, I think, the Netherlands. He invades England. James leaves, hops on his bike. We'll see you next time. And then Parliament comes in and it sort of asserts its authority by offering the throne. Actually offers up the throne to William of Orange and Mary. And then they present this document which established the principle that the monarchy could not rule without parliamentary consent, laying the groundwork for constitutional monarchy. This enshrined. Well, I don't like to use the word enshrined, but it averred essential rights and liberties, including freedom from arbitrary arrest and the prohibition of cruel punishment. They're just sort of fast forwarding. You got the 18th and 19th centuries. You see a sort of gradual erosion of monarchical power and the steady rise of parliamentary sovereignty. You got the Act of Settlement in 1701, which ensured Protestant succession, but further limited the monarch's interference in government. You've got the union, this union with Scotland in 1707 and Ireland in 1801. That's also got constitutional significance, obviously, because that is literally shaping the modern United Kingdom that we know today, which still exists today, this union. So that sort of came about in the 18th and 19th centuries. And then in the 19th century, you kind of have the reform movement. You've got the development of the modern parliamentary system. You've got the Reform Acts, which began in 1832, expanded the electorate, curbing aristocratic dominance, I would say. It sort of laid the foundation for modern representative democracy, which is huge. It's key. You got the rise of political parties as a result. You've got the Whigs and the Tories, who were kind of dominant at the time. Later became the Liberals and the Conservatives. Conservatives still informally called Tories. And then you've got the Parliament Acts of 1911 and 1949, which curtailed the power of the Lords, which is basically, I think, the moment which is where the Commons basically says, okay, we are the dominant house because we are the elected house. The Lords is going to exist, but we are the dominant house. We can pass legislation even if the Lords don't agree, because we have that right, because we have been elected by the electorate. And then, the Constitution is always evolving, as we know, and that's always transforming throughout the 20th and 21st centuries. You have new modern challenges that it has to adapt to and be flexible to. You've got universal adult suffrage, which obviously should have been a thing. That comes about in 1928, by the way. 1928. It took them until 1928 to adopt universal adult suffrage through the Representation of the People Act. I mean, that's just nuts, but that's history. And then you've got things moving further on to joining the European Union. You could argue, well, very fairly argue. I think it's a fact. The UK's membership in the European Union from the 70s is raised huge constitutional questions. You've got EU law, this whole body, this whole legislative framework that you're now going to have to incorporate into your domestic statute book. That's a huge constitutional question, and questions were asked at the time, and it was actually dealt with fairly well, I reckon. I mean, we saw what happened later down the line regarding our membership, but it worked. It worked. You have the European Convention on Human Rights. You've made them subject to the European Convention on Human Rights just by an act of domestic legislation. You passed the Human Rights Act 1998 to incorporate the European Convention of Human Rights and subject UK citizens to that. That works. That is a good way forward. But then, obviously, as I say, like, you got Brexit, leaving the EU, which, I mean, obviously the referendum was 2016, but it came about in 2020 that we actually left. That, again, a massive constitutional shift. You had a lot of gammons kicking off about parliamentary sovereignty without actually knowing what it is. You've got the issue of devolution, of course. Devolution, giving more powers to Wales, Scotland, Northern Ireland. Yeah, that's a big constitutional thing, and it's, to be honest, half of it we still haven't quite figured out even now, 6 years down the line. So I think, at risk of going on too long, I think essentially the Constitution it's a product of evolution, continuous evolution, and it's shaped by social issues, political issues, legal developments. It all goes hand in hand, really. But I think that's why the uncodified nature of the Constitution plays to its strengths. Really, the flexible nature of it allows for this adaptation. It's got its challenges, it's got its drawbacks. And sometimes there's a lack of clarity or sometimes even stability. We saw that with some of the Brexit cases in the Supreme Court. The prorogation of Parliament that was rendered illegal or unlawful, I should say. So there's drawbacks, but I think the pros outweighs the cons here. The benefits of it, of the uncodified nature of it, you cannot dispute. You cannot argue against it. Really, you get some people popping up saying we need to codify the Constitution. Why? I do not see any reason we would have to do that. It's always going to remain a big debate, and that's fine. I'm here for the debate, and it's always interesting hearing the different sides and the different views on the matter. Yeah, I think it's a fair overview, a brief overview. So thank you very much. I'll catch you next time.